Good morning, I'm Ken Spector. I'm the senior partner in Spector Solicitors and we've been trading for over 25 years. I'm here today with Tracy Atala, who's a divorce lawyer with our business, and we're here to demystify some of the concepts about divorce. We're going to go through that this morning and try and do it in a very simple and transparent way. So how does a party commence divorce proceedings, Tracy?
We'll initially meet with the client, take their instructions and see if there is a possibility for conciliation. If there is, we refer them off to local conciliators and mediators. If not, we try to establish that the marriage has broken down irretrievably.
And what are, so as I understand it, there's 5 grounds for that. I think one of them is that the other party's deserted you, that you've been apart for 5 years, that you've been apart for 2 years, and that both of you consent to the divorce. So those 3 are fairly straightforward. I think there's 2 more, isn't there?
There's adultery and unreasonable behaviour.
So Tracy, we talked about unreasonable behaviour and adultery as the other 2 grounds for divorce. What would you have to prove before the court for those? How would you go about it?
Unreasonable behaviour is the most common ground. It's the easiest ground to obtain a divorce on. It's subjective. It's purely based on what the petitioner believes is unreasonable. It's fairly uncommon for a respondent to refuse a divorce based on unreasonable behaviour, as there is a consequence of costs.
What about adultery? How would one prove that?
So with adultery, if the respondent consents to the adultery, then the divorce goes ahead. If he contests it, then the petitioner would need to prove the adultery and evidence that the adultery actually happened.
So an inquiry agent or witness evidence, that sort of thing?
Photographs, anything like that.
So Tracy, what is the process by which we obtain a divorce? Can you explain that to me?
Yes, of course. We initially take the client's instructions. We'll draft the petition and the particulars for the client's approval. We often send a copy to the respondent, put them on notice of the proceedings. We do that especially with difficult respondents. We'll find that out from the client when they do instruct us. And then we'll file the petition with the courts. The courts will then send out a sealed petition to the respondent with an acknowledgement of service.
What's an acknowledgement of service?
Straightforward document. It's a court template sent to the respondent, and they basically confirm whether they're agreeable or not agreeable to the divorce, and it gives them the option to defend proceedings.
Okay. Well, in terms of them saying no, I'm not agreeing, that goes down another road entirely, doesn't it? But let's assume for the moment that they do consent. What process is involved in the petitioner actually obtaining what we call a decree?
So then, upon receiving the acknowledgement of service from the courts, we have the option to apply for a decree nisi. The decree nisi is an application to the courts confirming what reason the petitioner is requesting a divorce under. The application is in standard form. It's sent to the courts for the judge's approval.
Do the parties have to attend court?
No, it's not usual that the parties do have to attend court unless there is an issue of costs or if the proceedings are defended.
Okay. So let's move on from that. So you've obtained your decree nisi. It's difficult to put an exact time on it, but say 6 to 8 weeks on average, maybe?
So upon the decree nisi being pronounced, we can apply for the decree absolute 6 weeks and a day after that.
I know we don't always do that because there can be other matters concerned, and indeed I think we'll turn to deal with the other aspects of divorce. So perhaps we can deal with the issue of financial relief, which is obviously a massive concern to everybody involved in divorce, whether it be the husband or the wife. So how does the court go about dealing with financial matters?
So any party can make an application for financial relief. It is often the petitioner that will file an application for financial relief. There are various factors the courts take into consideration, including children and the length of marriage, earning capacities, income, and any capital both parties have.
Is it the wish of the court to try and put the parties in the position they would have been as best as possible, bearing in mind that there were two parts and now there's only one effectively?
So the courts somewhat amalgamate both parties' assets, and we start at an equal division of assets of 50-50.
When will the court move away from a 50-50 division? Are there grounds they will?
Yes, there are. There are various factors the courts take into consideration.
Mm-hmm.
The children being the first thing the courts will take into consideration. Lifestyle, earning capacity, the length of marriage, any prior agreements, behaviour. They're all aspects the courts will take into consideration.
So Tracy, we've got our decree nisi, we're in a position to apply for our decree absolute. We may delay that while we deal with finances. When do we decide that we must go to court, that we're not in a position to do mediation or negotiation?
There are various factors that we consider before going to court, and it's often that the respondent is being very difficult and he won't settle or she won't settle. And we do have to go to court. There is no alternative than court. I
mean, we recognise we issue many petitions for divorce. We litigate every day. So we know what's involved and we know how to do it. But in terms of, say, perhaps saving costs, or there's some areas of dispute but the parties don't want to enter into long-standing, long drawn-out battles, what are the other alternatives?
So we can negotiate through solicitors. We can have roundtable meetings where these negotiations can take place. Or alternatively, we can attend mediation.
What's a mediation? Who'll make the decision in a mediation?
So both parties are involved in making decisions to settle their finances. There will be a third party, a mediator. Mediation is not legally binding. However, what comes out of it is an agreement which we can often draft into a consent order, and this consent order can be filed with the courts and will be legally binding.
So we've dealt with financial relief. Let's turn to children. So how will the courts approach a custody dispute between husband and wife or civil partners?
So the courts will initially look at who has parental responsibility. It is the most common that both biological parents will share parental responsibility. The courts will then look at what is in the child's best interests. The courts do consider and do take into consideration that it is the mother, the primary caregiver of the children, who the children should remain with.
So, Tracy, let's deal with the issue of contact. Let's assume one party, the party with custody of the children, doesn't want to give contact to the other party. How do the courts approach that, or how do we approach it in terms of how we'll deal with it?
So prior to making any applications to court, it is often compulsory for both parties to attend a MIAM mediation, and both parties can discuss their child arrangements there. If they cannot agree in mediation, then we will have to proceed and commence court proceedings.
And how do the court make the decision? It's very difficult. Both parties are saying something different. Either party may be making allegations against the other. How does the court obtain the evidence to make a fair decision that suits both parties?
The courts have court officers known as CAFCAS. CAFCAS will conduct a safeguarding check in respect of both parents, and they will make recommendations to court. If allegations persist, it is often that the courts will request a social services report and various parenting courses for both parties.
And what happens in the interim? I mean, will the court give an order for interim, perhaps, contact which is supervised, for example?
Possibly, but each case differs.
And what criteria will the court ultimately determine on contact? And what right of appeal would a parent have who's been refused contact?
So it depends on the extent of allegations, and it is often that either party can make an application to vary a current consent order.
Okay, so it's not forever.
No, it doesn't have to be forever. Any party can always apply and have the agreement or the order varied.
So Tracy, let's deal with the issue of divorces for people from abroad. Clearly, London's a very cosmopolitan place. We're right in the centre of London here. How do people from abroad who perhaps don't speak the language, don't understand the divorce laws in this country, how do we help them?
We provide many services. We can refer them and bring in translators into the office to assist with any language barriers.
How does somebody from abroad decide whether to institute divorce proceedings in the UK or in England and Wales, I should say?
So London is becoming one of the divorce capitals of the world.
Why is that?
It's becoming more and more famous for having favourable decisions in respect of the weaker party, financially weaker party.
Mm-hmm. And in terms of how we would deal with a husband or wife who has a lot of their assets abroad, do we have the wherewithal to be able to trace that information? How do we go about that?
Possibly, and it depends on which country their assets are.
Mm-hmm.
So we often can use detectives and other companies to asset search them abroad.
Okay. What about language? Obviously, many people have a language barrier. They don't speak the language well. We obviously arrange translation services. I think we have a number of speakers of foreign languages within this business, including Arabic and Russian and Polish.
That's correct.
So people can approach us without fear or concern. If we don't have the language discipline within the office, then we'll arrange translators who are certified to speak for people who are involved in divorce proceedings. That's right, isn't it? Okay, let's turn to the issue of cost. I think the approach of our business is to be clear and transparent with clients about the cost of divorce proceedings. So we offer fixed fees. So we can tell a client up front what their divorce would cost, for example. We put that on our website at spectors.co.uk. And during the stages of divorce, be it for financial relief, be it for custody disputes, we will advise. We will offer fixed fees at various stages. Is that the way we approach it? Isn't
That's
it?
correct. We try to be as transparent as possible with clients, so that they do know the extent of costs that are involved.
What about a weaker party? That's the party who perhaps doesn't have control of the money, but is the husband or wife of a wealthy person or civil partner. How do we help them?
We can often refer them off to various financial institutions.
Mm-hmm.
They will have to seek their own independent legal advice in that respect, but there are parties or organisations who can help them.
So we can refer them, but to ensure there's no conflict of interest, they have to be independently advised before they agree to finance elsewhere. So Tracy, that's really been very helpful, and I hope that's made it clearer to our prospective clients as to what we can do for them. Just dealing with the issue of why Spectors. So we've been in business for many, many years, so we have a lot of experience, and we only employ people who we believe are capable and prepared to fight for you. That's not a cliche. It's the reality is that the other party to a divorce has their solicitor working for them, and we want to look after your interests. But we want to be transparent and honest with you and open at the very beginning as to exactly what's involved, what your chances are of getting the kind of result you want. You don't just want a lawyer who's going to tell you what you want to hear, but on the other hand, you want a lawyer who's going to be robust and clear and honest in the way that they approach your case, so that ultimately your future will be what you want it to be. Divorce is obviously an upsetting, difficult time of your life. The last thing you want is a solicitor who doesn't support you. So we're there for you, and if you do come to us, we'll look after your interests to our best ability. So if you want to instruct us, you can telephone us on 0207 251 9900, or alternatively, you can fill in the contact form on our website, which is at spectors.co.uk. Thank you.